Now we are continue to our third part of the webinar about justice. Around the world, road deaths result in less investigation, less serious criminal charges, and lighter sentences than other cases of involuntary killing. Criminal charges are often outdated and reform taking too many years. More about the justice and especially criminal justice in United Kingdom will present Mrs. Victoria Lebrec, who is head of policy, campaigns and communication at Roadpeace, and she has also been a victim. Roadpeace is an NGO, member of FEVER, and from its beginning, and they have published many papers on post-crash response, especially on justice for road victims. Victoria?
Okay, criminal justice for crash victims. I'll talk to you very quickly about Roadpeace. Roadpeace is the national charity for road crash victims. As you said, Benita, it's been a long focus on the importance of criminal justice. The founder, Brigadier Chowdhury, whose son was killed in 1990, has done extensive campaigning, and she was also president of FEBRA on the issue. And I think, you know, civil justice, I mean, criminal justice is so important because it's not about vengeance, and it's not about, you know, seeking retribution for what happened. I think sometimes people get confused around that. I was very seriously injured in a crash myself. I was cycling to work and a lorry did a number of things, criminal things, wrong, turned left across my path and crushed me, and I lost my leg in the crash. And when I tell people about what happened to me and the criminal justice outcome, people think, my goodness, like justice wasn't served in your case. The driver was charged originally with causing serious injury by dangerous driving. It got downgraded to careless driving. We don't have a charge at the moment in the UK for causing serious injury by careless driving. So he got 6 points off his license and a £750 fine. And when I tell people about this, they think, oh my God, that's, you know, that's not justice. How could this have happened with the injuries that you suffered and all that you went through? How can this be the case? But justice, I think, is more than that. I think I had such a quality investigation that was done by the police. I was supported every step of the way. And for me, it wasn't about sending the driver to prison for years and years and years. That's not what I was after. So I think even though the sentence was very light, I think justice is more complicated. I'll talk very quickly the key issues in terms of criminal justice in Bristol, and I'm sure, sorry, that's my doorbell that's just gone. My sister will answer it. So key issues for criminal justice in Britain. I'm sure these are replicated across Europe. I think the first thing is that there's a lack of priority for road crime. The Home Office does not identify road crime as a priority. This contributes then to a lack of investigation. There is not enough funding for investigation. There's not enough training. The victims that we speak to at Roadpeace, and I think it's similar to what you were saying earlier from Pat, is that so much of the support has to be around information and advocacy and help with the criminal justice system. You can't expect people to be able to go through it without information support. I think one of the other factors that impedes criminal justice, there's an insufficient willingness to prosecute for road crime. I think there's a lot of factors at play there. There's a lack of funding for the CPS, and I think also the way that the targets are put out, it's all about getting a conviction at any cost. So that's where you end up with the issues of downgrading to lower charges. And then there's the issue of the charges themselves. It's not clear often what makes up careless driving and what makes up dangerous driving. There's a lot of overlap and it's not clear. And also inappropriate sentencing. I think families often feel that sentences are not long enough, especially when there's death or serious injury that's involved. And a wider point actually that I haven't put on this slide, but I think is again important. Obviously criminal justice is based on the perceptions of the public to a certain degree. And you know, the use of the word accidents, you know, we still see very minimal culpability and very minimal intent in terms of road crime. And I think I noticed even during the presentations of the colleagues, the word accident was used a lot, and I think that then plays a part in terms of how criminal justice plays out in Britain. So what does criminal justice mean for victims? I'm going to go through a few cases. The first one I think maybe most of you will be familiar with is the Harry Dunn case. It was August last year. Harry Dunn, 19 years old, was on his motorbike, and Anne Sakoulas, who is the wife of a American diplomat, was driving on the wrong side of the road, crashed into him and killed him. I mean, their story is really quite incredible, really, when you think about it. I think initially the CPS said, there's no way that you're going to be able to, we're not going to be able to charge this. And it's only through the actions of their neighbour. So that's the person pictured on the screen there. He's a guy called Rad Seeger. He is a lawyer by trade. And he heard about what happened to the family. He went around to see them, and he's now their spokesperson. So now they are going through this terrible situation where they're trying to get Anne Sakoulas. She fled to the States after this happened to try and get her extradited and come back to the UK to face justice. And I think, you know, that's awful, and it's so traumatic for the family to then have to go through all of these proceedings after the worst thing imaginable has already happened. And I'm going to play you quickly so you understand the impact. I've got a clip that Harry Dunn's mother sent through for another webinar that I had done, but I think it's very applicable to show it to you here. I hope that the sound works. Let's try. Someone let me know if it doesn't.
Hi all, I'm Charlotte Charles, Harry Dunn's mum. I'd like to start by firstly thanking everybody for their support. Without it, there are some days that there's no way we would have got through. I also need to say a huge thank you to Rad Seeger. He's been our advocate and our family friend and our spokesperson. Without an advocate like Rad, there's absolutely no way that we would be as far along in our grueling campaign as we are now today. I just need to urge anybody out there that feels that they've suffered an injustice to just be strong, stand up for your rights, continue to fight. Your loved one was extremely important. Just keep going. You'll get the results that you need in the end.
And in the second case now, so I'm sorry, I'm racing through this very quickly because I know we're tight on time. So Craig is the gentleman pictured in on this slide here, and that's his partner, Joyce. He was cycling and had an altercation with a driver. Driver speeding nearly went into him. When there was a giveaway sign, Craig stopped him and said, you know, what on earth are you doing? You nearly killed me. And then the driver looks him in the eye and intentionally puts his foot on the pedal and crushes him against another car and continues to crush him. That was proven in court as to how that had happened. And you can imagine with those kinds of injuries, I mean, this is Craig in intensive care and learning to walk again. It's a miracle that he's alive. He was in a coma for a very long time, and yet suffered horribly and has life-changing injuries as a result of what happened to him. But in terms of the criminal aspect of this case, I think the reason I'm telling you about this is because I feel that because there was a car used instead of, say, a knife, you know, a kitchen knife or a bottle, justice was not served. And I think this goes back again to how we view the car. So this is the timeline of the case. Craig was crushed by a car intentionally on the 14th of June in 2018. When the police come and speak to Joyce's partner and his family, there's discussion around attempted murder because there's intent there. And Craig, you know, what do you expect would happen when you crush someone with a car? That's attempted murder. Following that, the official charging decision, I think the police or the CPS felt that there was a much greater chance of conviction with grievous bodily harm with intent. That is a crime that carries a long sentence, but it's slightly below attempted murder. And this is where it really falls down. The CPS, without telling Craig and Joyce, when the trial is happening, they add in for the jury an extra charge of causing serious injury by dangerous driving, which has a much lower sentencing. They don't tell Craig and Joyce. And then the driver ends up being convicted of causing serious injury by dangerous driving when the judge said in the closing comments that this man, the defendant, had used his car effectively as a weapon. And I think, again, that just goes to show that the charging system does not work properly in Britain for these. It's an unusual case, but this shows that people don't think the same about using cars. So some quick recent developments on criminal justice for crash victims in the UK and Britain. So the Ministry of Justice has been consulting on something called the Victims Code. The lady pictured on this slide is Claire Waxman. She's the London Victims Commissioner, and Roadpeace works very closely with her. Her post, and I think this is something that's interesting, I'm not sure if it exists in other countries. She is an independent advocate. She's employed by the Mayor of London, but she's an independent commissioner whose sole job it is to advance the causes of all crime victims. That includes crash victims. The Victims Code is something which is national, which exists, is essentially a set of entitlements that victims of all crime have. So it covers things like, you know, having access to specialist support. If you're a particularly vulnerable victim, you are entitled to having faster access to things. It also talks about having proper access to information and being informed in the right way. Also things like the victim's right to review when the CPS have decided not to prosecute. So things like that. So it's a good document. There's lots of things that could be improved with it, which they've been consulting on recently. And we're hopeful that this will improve things for crash victims because there's cross-party support now in Britain for a victims law. Currently, the Victims Code is something which is just a set of entitlements and not right. So say the police or the CPS don't abide by the Victims Code. At the moment, there's not really that much you can do apart from complain. And not very much will come of it. However, if it's a statutory right, we hope then that victims will be treated better. The second set of developments that's happened recently in Britain on criminal justice is around sentencing and reviewing some of the driving charges. I spoke earlier about my case where the charge of causing serious injury by careless driving didn't exist. In 2017, the Ministry of Justice put forward a set of proposals and they said that they would implement them. One of them is introducing that new charge. The other is extending the maximum sentence for death by dangerous driving to life in prison, and also for to do the same with causing death by careless driving under the influence. So these are good steps, and I think it's going to take a little while for them to be put in place. We had, in terms of the maximum sentencing to being changed to life, I think sometimes that's something the media likes to jump on as it being the solution, and you know, that we're taking road crime seriously. I think, you know, the difficulties are a bit wider than that, and that often no one gets prosecuted for dangerous driving in the first place. That the numbers are very low. But one of our members, Kira Lee, who's pictured here with her husband Eddie and her son, Eddie was killed whilst riding his motorbike by a driver that was convicted of death by dangerous driving. Kira, when I spoke to her about it, she said that the driver had ended up receiving a sentence of just 22 months. And Kira is not at all a vengeful person, but I think it's about having a proportionate sentence to your loss and to the crime that the person has committed. And I think what's also interesting in her case is she said the judge wanted to give longer, but because the driver pled guilty, then it's 30% off. And because of other mitigating factors, which, you know, where he tried to help Eddie at the scene, things like that, the maximum that he could give was 22 months. So I think by extending the maximum sentence to life, it will give judges a bit more of a scope to give more appropriate sentences for these quite extreme and sad cases. So what needs to change in terms of criminal justice in Britain? You know, I think one of the main things is that road crime needs to become a priority for the Home Office. I think it's crazy that there's so many people that are killed. I think last year 1,748 people killed in Britain and over 25,000 seriously injured. This needs to be a priority in terms of the number of people it's affecting. And we also need better information and data on offences. At the moment, we know how many drivers are prosecuted, but we don't know the number of victims that are impacted by those prosecutions. There needs to be more training and more funding for collision investigation. I think Benita, you said earlier, is the cornerstone of justice, and it really is. Everything falls down if we don't have a good collision investigation. We need increased information and support for victims. There's not enough funding at the moment for that, and I think victims need help to navigate the criminal justice system. It's not fair to expect them to be able to do it alone. The most important one for me, and I know Brigitte did, founded a lot of this work, is around surveying victims. For other types of crime, there will be surveys done as standard. That doesn't happen with road crime victims. So it's very difficult to understand what the needs are and what they need as part of the criminal justice system. And we need a justice system which seeks justice and not just convictions. This is where we end up with people just being prosecuted for death by careless driving when they've done, I mean, I spoke to someone yesterday about this. Her son was killed by a drunk driver speeding with previous convictions of drink driving, and he failed to stop, and the Crown Prosecution Service are prosecuting for death by careless driving. That's not right. And I think, you know, a big motivator in that is that the CPS just want to get a conviction at any cost, as opposed to seeking justice for families. And we also need a review of traffic offences generally and sentencing. I think, as I said earlier, the difference between careless and dangerous is not clear. And ultimately, we need to get more prosecutions for dangerous. Thank you very much. I think hopefully we're okay on time. Thank you.
Thank you. Thank you very much, Victoria. Well, crashes result in lost work and incomes and throw families of victims into poverty. Often, the whole family suffers. In addition to lost employment, there will be additional expenses with medical care or funeral costs. More about civil justice now will tell us Mr. Koen van Wonthergem, who is managing director in PEVEL. This is an NGO in Belgium, which is for parents of children who are road victims, and he is also a board member of PEVEL. Koen, the floor is yours.
Thank you, Benita. Do we still have time for this last piece?
Quickly.
Quickly. Yeah, I'm wondering for two reasons. Because I was asked last minute to replace our Italian friend, and I did have time to prepare some special intervention. I went back to my intervention of years ago in Istanbul for the FEVEL conference, Importance of Justice for the Quality of Life of Road Traffic Victims at that time. And that intervention has as subject the strict liability. At that time, there were only half of the European Union member states that knew the system of strict liability. And the only thing I could get since yesterday until now about a more actual status of this strict liability, I found that at the moment there are only 4 other countries in Europe that have yet to introduce the concept of presumed liability to their legal systems. That means Malta, Cyprus, Romania, and Ireland. That also means that my intervention becomes less important, I would say, because we have only to lobby as favor, I think, in these 4 countries to have this system of strict liability, which will be a very evident system as from the moment that we are confronted to automated vehicles and transport. As we know, for self-driving cars, an analysis of new rules were already adopted or under consideration that shows that up to now, only a few countries have adopted general provisions for using driving automation or plan to do so. That means Austria, Germany, France, and Switzerland, apparently, while other member states have adopted specific regulations for pilot tests, apparently. But I apologize to join the meeting a bit late, first of it. There was another reason, and I want to stress this. This morning I attended a big cycling event in West Vlaanderen. It's a province 100 kilometers away from Brussels. An event, the Tournée Flandrienne, which is a charity event where the profits will be given to our association. On the way to the event, we listened to radio news, but we were confronted to a fatal accident this very morning, and in the very small town of the charity event itself, Wonthergem. A 12-year-old girl lost her life. She was on her way to school, cycling next to her friend, and was hit by a truck that wanted to overtake the 2 cyclists. Moreover, today is a special day within the Mobility Week, European Mobility Week, a special day where the advantages of cycling and walking to school are put in the spotlights. The event organizers were devastated by this almost diabolical course of events and dedicated the first bicycle ride to the young victim. That means reality is still there. Yesterday, today, tomorrow. I'm wondering if many people who are attending now, most of the people are aware of this strict liability system again. And is it okay that I come back with this older intervention? Because in the meantime, several countries, also Great Britain, joined the club of the strict liability. But participating in traffic is by far still the most practiced social activity of each of us. From childhood to old age, we all take part in traffic, whether we want or not. It's, however, an activity with very complex and high impact legal implications. When a traffic accident results in serious, even fatal injury, these implications can lead to legal procedures and outcomes that in the past were all too often opposed to the call for justice of the victims. And in the present, this is often still the case. However, Lord Denning, British Minister of Justice, stated in 1982, in the present state of motor traffic, I'm persuaded that any civilized system of law should require, as a matter of principle, that a person who uses this dangerous instrument on the roads, dealing death and destruction all around, should be liable to make compensation to anyone who is killed or injured in consequence of the use of this. There should be liability without proof of fault. To require an injured person to prove fault results is the gravest injustice to many innocent persons who have not the wherewithal to prove it. And in many countries, many European countries, for road traffic personal injury cases, the burden of proof is still on the victim to prove. Many European countries becomes now only 4 European Union member states. Proof still on the victim to prove the other party was fault. The injured party in a crash between a pedestrian or cyclist and motor vehicle is most likely to be the vulnerable road user. Under strict liability, the burden of proof is reversed. Vulnerable victims, not drivers, are the ones assumed innocent with regard to causing injuries. Strict liability only applies to civil, includes eventual moral compensation, and does not affect eventual criminal prosecution. However, at that time, 7 years ago, many European countries already had a system of strict liability. Responsabilité objective, objective responsibility. Notably, at that moment, and in chronological order, it's always interesting to hear that. First, Denmark, then Austria, Germany, Italy, Norway, now the member state, Sweden, Finland, the Netherlands, Luxembourg, Switzerland, Spain, France, Belgium, Lithuania. Since then, our friends in Eastern Europe joined certainly the club, except Romania, apparently, and then Malta and Cyprus, of course. But also Ireland. It's yeah, a bit astonishing. What happened in Belgium? Until the entry into force of the law of 30th of March 1994, the compensation of traffic accident was handled by the liability rules of common civil law. But the French Badinter, la loi Badinter, led the Belgian legislature to vote its law of 30th of March 1994, to which some amendments were added in 95 and 2001. It changed the damage regulations by introducing the notion of vulnerable road user and by putting the charge of the damage compensation automatically on the insurance company of the involved motor vehicle. The present version of the law states that in case of traffic accidents implying one or more motor vehicles, with the exception of material damage and damage to the driver of any involved motor vehicle, all damage to the victims and their claimants resulting from physical injury or death are compensated jointly by the insurance companies covering the civil liability of the owner, driver, or user of the motor vehicle. Apart from the advantage for the vulnerable road user, the victim of an accident, it may also be noted that this legal system reduces the cost for the public health insurance by handing the obligation of damage compensation over to the private insurance companies. Conditions giving right to this automatic compensation in favor of the vulnerable road user can be summarized as follows. It has to be a road traffic accident, of course. The road traffic accident has to occur on the public road, areas open to the public or areas not open to public but accessible upon authorization. One or more motor vehicles or trains even must be implied in the accident, and the accident must have resulted in physical injury. The victim does not to prove that all conditions need to be fulfilled together in order to obtain a damage compensation. It's a law of civil, under which means that no one, not in any circumstance, can deviate from it or ignore it. Also, in case of an accident abroad, the automatic compensation is applicable, which is important, of course, in European Union with 26 systems. It's important to know that in all over these countries, the same system is applicable. Compensation is applicable with one single exception. That means when the injured vulnerable road user is a passenger in a Belgian vehicle colliding with a non-Belgian vehicle. That's for the problems or crashes abroad. The beneficiaries of the automatic compensation are the vulnerable road users directly implied, their relatives and claimants, the driver in his possible quality of claimant to a vulnerable road user, the driver who has become a vulnerable road user. Only one remark in this context: victims older than 14 years old, 14, who in a way sought the accident, are excluded from this compensation system. Which type of damage is then compensated by the system? It deals with all damage resulting from physical injury or death, including damage to clothing, excluding what is packed in the luggage, all economic, moral, domestic, aesthetic, sexual, and usufruct damage must be compensated. The vulnerable road user has up to 5 years to introduce his claim to the insurance company of the driver of the vehicle and or to the police court. In Belgium, police courts also act as traffic courts. It may be said that the system in Belgium functions well and swiftly. This is possibly thanks also to another kind of system, which is a table we call indicative, table indicative, which is a list drawn up by the judges of the police courts. It details fixed amounts for certain damage categories. This table is not a law, but it's generally accepted and used also by insurance companies. It does make it more difficult for victims, however, to claim higher compensations than what is indicated in the table. But again, it must be said that the right to compensation of proven damage persists. Another somewhat perverted consequence of the advantageous automatic compensation system based on the indicative table is that victims or their claimants, once the compensation is received, no longer have any say in criminal procedures. If any, of course. Because of the compensation as a kind of settlement, friendly settlement, their claims are considered to be fulfilled and they can no longer be a party in the following procedure. This can, in some tragic cases, have an impact on the victim's process of mourning. The question of what is the best system remains open. That's what I wanted to add to this webinar.
Thank you very much, Koen. There will be a record of the session, so you could watch it later.